welcome to the Tiisa Group Glass Balls series. My name is Pearl Hlabangana, and in this series we'll be talking to you about data protection. We are also joined by our privacy expert who will talk about data protection risks and mitigation strategies. To close off, we're going to leave you with some practical steps on how to implement your own data privacy or data protection program. So grab your coffee, sit down, and let's get going.
Are you responsible for data? Does information security keep you up at night? Are you worried about the protection of personal information in your organizations in general? Or what about a breach? Do you know what you do in a breach? Do you even know what constitutes a breach? Do you think your organization should be doing more around data protection and needs specialist knowledge to check that you've been doing the right things? Are you concerned that you haven't been doing enough around data protection? If you confidently answered no to all these questions, then well done, and you most probably can drop off at this point. But if you answered yes, or have any of these questions still in mind, or just simply want to know more, then stay tuned. Data breaches have become more common and more severe, and we've seen more hackers becoming agile and the threats of their hacks becoming more sophisticated, sometimes through the use of advanced technology such as machine learning to launch attacks. In recent years, numerous issues have arisen around the way enterprises or organizations treat users' information. Personal data is being processed, often without users' consent. We've also seen that research shows us that consumer attitudes towards digital security is changing, and people are becoming more aware of their online threats. In fact, recent reports also suggest that the main issue troubling connected users concerns the safety of their personal data. So that is what the fuss is. The fuss is that consumers are becoming more and more aware and concerned about their data and how it is collected and used by organizations. In today's highly evolving marketplace, it's always best for us to defer to experts who specialize in these specific areas. And that's what I have for you today. Up next, let's hear from our lead privacy consultant. Privacy expert Russell Nell has spent more than a decade asking and sometimes even answering questions like, how can you use compliance to improve your business rather than just check a box? Why don't executives take privacy and information security more seriously? And how do we make topics of privacy engaging and more fun? Unlike many consultants and compliance practitioners, Russell prefers to focus on practical and systemic solutions which take your organization's specific content into consideration using a people-first approach. He's also set up governance structures, embedded privacy into organizational cultures and operations, drafted countless policies and other governance documents. I really could go on, but for now, let's cross over to Russell Nell, who will unpack what is required from us from data protection laws, the risks that are associated with some of those data protection laws, and how the level of compliance differs for different companies. Over to you, Russell.
Thanks, Bill. Just a quick thing, I'm not a lawyer, so I don't look at privacy from a purely legal perspective. I also look at it from a compliance perspective, from the risk angles. I look at information security, I look at your processes and systems, and I look at, of course, your data handling processes and practices. It really is a multidisciplinary field, and it requires looking at it from a lot of angles. If you don't, you're unlikely to have a very successful privacy program. In fact, most of the privacy programs I've worked on, because they're too focused on compliance, end up not complying anyway. So in order to keep this simple, I think I'm going to focus on privacy from a compliance perspective today. What are the laws and what are the requirements of the laws that you need to focus on in order to achieve privacy compliance? But in order to do that, you must understand that you are going to need to make a lot of changes, or you may be required to make a lot of changes. Privacy is more about change management than actually complying with the law. So let's start just to frame it quickly. What are the laws? Well, there's two main laws that we look at. Being from South Africa, we naturally need to consider our Protection of Personal Information Act, or POPIA. It hasn't been fully effective yet, so we do have an information regulator, but they aren't yet enforcing. And so we are waiting for that enactment date to happen still. A little bit further north in Europe, they have finalized their General Data Protection Regulations, or the GDPR, and those have been in effect since May 2018. So if you are doing business with organizations in Europe, there's a very good likelihood that you have come across the GDPR and that some of your clients or customers in that region may need you to comply with that law as well. The great thing is POPIA and the GDPR are substantially similar. There's a lot of similarities between them. The lawmakers who drafted POPIA had sight of the drafts of GDPR, and so they were able to incorporate those into POPIA, and some of the things that they missed or that they didn't have, they've now included in the regulations which they have released from a POPIA perspective. So if you can comply with POPIA, you are substantially able to comply with GDPR. There may be a few additional things that you need to add or tweak, and likewise, if you can comply with GDPR, you're likely to be able to comply with POPIA. However, there's one key difference, is that POPIA requires that you look after the information of juristic persons, not just the individual. Juristic persons are your companies, any kind of organization really. It can be something small like a body corporate, for instance, or it can be something like a massive enterprise. The GDPR and the European Union only look at the privacy of individuals. So all you need to do from a POPIA perspective is expand it to include other information of your suppliers, of any vendors that you might be using, any third parties that you might be working with. So why do you need to comply? Well, it's trendy, right? So everybody's doing it. That's not the real reason, but really from a South African perspective, we do need to start aligning with some of the international data protection laws and international organizations. As I've already mentioned, some organizations that you might be working with already might require that you are compliant, and we want to try and avoid the fines. The fines can be very hefty. POPIA looks at fines of 10 million rand, but as we've seen internationally, even though the law says 10 million rand, sometimes it's many orders of magnitude larger than that, because they hit you not only for one breach but for multiple breaches in one go. The GDPR is a lot less forgiving, and those fines can be anywhere between 2 to 4% of your global annual turnover, or 100 million euros, whichever is the larger, and that's a lot of money. That's enough to cripple even some of the largest organizations in South Africa. The second reason that you might want to comply with these laws is because of the rising cybersecurity threats. Hackers want information to be able to commit fraud and identity theft. Data has become a new kind of currency, and so if it's valuable and it has value, then you can bet your bottom dollar that there are going to be criminals who want to get access to this, mainly for profit. You might also want to just be a good corporate citizen. Complying with privacy law is good for business. It inspires trust with your customers, and it's good for your reputation. But maybe I'm just being a bit idealistic and naive. What I do know, though, is that doing the wrong thing is bad for business. Can you afford to lose clients in this current economy? Don't let poor data protection practices be the reason that your clients abandon you. A study conducted by Forrester Research found that 2 in 5 companies have difficulty attracting new clients after they've had a data breach. So for those of you that don't know, data breach is when you lose your client's personal information or it falls into the wrong hands, and it can be negligence, or it can just be a mistake or an accident, or it could be from some sort of malicious actor like a hacker or something like that. Anything where personal information falls into the wrong hands is considered a data breach. Something as simple as one of your staff accidentally sending a spreadsheet to the wrong person via email. There's also increased risk to data and information at the moment with everybody working from home. So more and more people are working remotely if they are able to, due to social distancing and in some case governmental lockdowns. So I'm going to ask you, as a business owner or a business manager, do you know where all your data is now? Because it's all over the place. So actually, in its current state, it now makes it easier for you to be breached. How secure are your employees' home Wi-Fi connections? Have you given them connections to use? Also, who else could be connecting to these connections? Are their family members or their children using the same computers? And what are they doing with them? Do they have access to that information? Is this something that could cause you a problem in the future? In the future, your reputation as a company will be everything. So you can't afford to have somebody complain about your information handling practices on social media, or worse, if they take a complaint to the regulator. So just what is personal information anyway? Well, it's the definition is very broad in any piece of law that you look at, but you really are looking at a number of categories of information. I'll take you through these now. Any kind of identifying number. This could be a bank account number, an employee number, an internal customer code, anything that you use to identify them. Remember, personal information is anything that can be used to identify somebody, whether it's on its own or whether it's in conjunction with other information. Any kind of demographic information that you collect. This could have to do with race, it could have to do with religion, it could have to do with income, age, gender, anything that you might use to segment your clients, information that you might use or that you might collect for that purpose. Some of the categories of sensitive personal information include things like medical or health information, criminal background, and then there's just the standard things like contact information, education history, your financial information, employment history. Then there's some more esoteric or interesting categories of personal information. These include things like tracking or behavioral information, and they include preferences and views or your opinions, and also opinions about you. So if somebody has an opinion about you, like maybe your manager has an opinion about your performance at the office, or your mental health professional has an opinion about your mental health status, those are opinions about you and are considered your personal information. Information about children is also included and is usually separated in law because children are seen as sensitive, they're seen as vulnerable in terms of the law, and they need to be protected, and we need to protect them a little bit more. The last few categories that I've got here are location information, so where you are, or possibly even online, your online location information, IP addresses and so forth. Your biometrics, which are any physical features that can be used to identify you. These include your retina, your iris, your facial geometry, your hand geometry, your fingerprints, and several other things like that. The challenge with these ones is if these are compromised, you can never change them. And then finally, any correspondence which might be seen to be confidential in nature. Privacy law has a number of requirements. These include accountability, like putting somebody in charge of your data. In South Africa, you are obliged to appoint an information officer, or at least make sure that somebody in your organization is an information officer. And from a GDPR perspective, in certain cases, you need to appoint what's called a data protection officer. Essentially, the roles are the same, and ideally, they should be reporting into the highest levels of management so that proper decisions can be taken and can be made. If I look at one of the other big things that privacy law talks about, everybody's always talking about consent. And it's important to know that consent is one of these things that can be given and taken away almost on a moment's notice. So you need to make very sure that if you need consent for something, that you are getting it in an appropriate way, that you can make sure that you can demonstrate that you've got evidence that you got that consent. And this especially is true when it comes to things like digital marketing or direct marketing. You may contact people to get their information, but if at any point they want to opt out, you have to provide mechanisms for that and make sure that you're tracking that and that your systems are capable of doing it. What about quality? Privacy looks at data quality. Obviously, data has a value, but it has a value over time. So as time goes by, data starts to degrade. It becomes less useful. Maybe it becomes less accurate. People are changing phone numbers, moving addresses, changing jobs all the time. If you've got old and outdated information, it becomes less useful. And under most data protection laws, you are responsible for the quality of the data that you're collecting. You need to make sure that it is accurate, that it's complete, that it's up to date, and that it's not misleading. When I say not misleading, if you've got data from that's too old, it might cast somebody in a bad light. Think about a credit report, for instance. 15 years ago, I might have been in significant debt, but today I might be a multimillionaire. You can't be making decisions on bad data. The next thing that you need to make sure that you do is your openness and notifications. So I know it's funny to talk about a principle like openness when we're talking about privacy. A lot of people think privacy is about secrecy, but it really isn't. It's about this openness. You must be notifying people what data you're collecting. What are you going to be using it for? Is it optional that they can provide it, or is it mandatory for the purpose? It really is about the context of the data. Then we look at information security. And information security is really the technical and the organizational controls that we've got to put in place to make sure that our information is protected. It's things like encryption, making sure that devices have got passwords, making sure that servers have got access control so that only certain people can get access to them, that it's not just a free-for-all, that access to data, especially personal information, is based on the role that the person does. Don't just let everybody have access to everything. That puts you at unnecessary risk. So you could also be transmitting data all over the world using third parties, vendors. I know a lot of small organizations that use other people to do their data processing, whether it's collecting the information or processing it on their behalf or storing it or hosting their systems or their networks or their environments. So it's important to make sure that your contracts are up to date, that you've got the right things in place. Then what about handling of data? Do you know where it is? Do you know who has access to it? Have you got any standard processes for this? I already mentioned third parties, but I can't stress enough how you should have a good solid contract in place. In the GDPR law, it requires the adoption of what they call standard contractual clauses, which really look at the details behind the handling of personal information. We're not just talking about your standard confidentiality and non-disclosure clauses. That's the secrecy aspect. We're also talking about the general handling. So how does information get handled? What are we doing with it? What are the requirements of them to notify you if there's a breach? What happens if you terminate the contract? Are they obliged to return the information to you? Must they destroy it off their system? Must they provide some sort of attestation in terms of that destruction? How do you make sure that once you're no longer working with somebody that you have all of your information back from an operational perspective, and also that they don't have access to it anymore? So it's more than just keeping it secret. It's about keeping it safe. And then privacy is about making it personal. Can people get access to their data? Are they able to correct it? And are they able to ask you to stop processing it or stop using it if they're feeling uncomfortable or if they don't want you to use it anymore? Obviously, depending on the industry that you're in, there may be certain laws that mandate that you keep information for a certain period, but after that, you should be destroying it. Now, I could talk about this topic for days or even weeks on end, but in this short introduction, I just wanted to get you thinking about some of the things that you need to do. I'm going to hand back to Pearl now, and she's going to discuss some of the key steps that you can take in order to get yourself started and get yourself going really quickly.
A resurgence of privacy regulations has left organizations struggling to protect personal information. And that's why it's so important that you learn and you take the lead from advisors that will help you to go beyond just complying with requirements, but also to help you build trust with your clients, with your consumers, with your users, and even help you to stand out from your competitors. So thank you for the insight, Russell. Now that you have all of this information, you may still be wondering, what are the next steps in implementing a data protection program? Before wrapping up, let's have a look at the top 3 things that you need to consider. Step number 1, get somebody to do it. If it's going to be yourself, make sure you're educated, or if it's going to be somebody else, make sure that they are just as equally educated and have the appropriate privacy certificates. If you're going to consult with the legal or compliance fraternities, that's also okay. But don't just rely on them, as they tend to look at privacy from only that aspect. Step number 2, know where you stand. What does your current privacy picture look like? So assess your situation and look at what you need to comply with, what you need to change in your business, and use this opportunity to decide where you want to be. Use the privacy compliance process as a critical driver to help you with the management of data and business processes across your entire organization. Step number 3 is to start small. Make sure you break up the program into small, manageable chunks. Start with those areas that are most important to yourself, your clients, or your partners. So this could be your communication processes, your privacy documentation, your websites, your breach management processes. The most important thing is that you don't stop. Make sure that you build this into your daily tasks and operations. And remember that this is a journey, and the most important thing is to get started and working towards your objectives.
Thank you for joining us. We would love to hear from you, so please drop us an email at info@tiisagroup.co.za, or you can contact us on our mobile lines. Take care and stay safe.